My story this morning comes out of Law 360, and once again, Jenny Beth is not monitoring me very well, so I'm unsupervised. Watch out. Okay, this story involves two guys with almost the same last name, Josh and Mackey. And Josh, I think he had Doctor's Own in Colorado, was a dispensary he owned. He then decided with this guy Mackey to go to Maryland and open the Doctor's Own Maryland. And they set up an LLC called Culta. And Mackey had his own business called Trellis Incorporated. And it seems that Josh had a misdemeanor on his record. They made a private agreement that Josh would step out of the LLC until they got a license, and then he'd come back in. Well, you know, as it works out sometimes in the drug trade, people are lying motherfuckers. And he said, no, I'm not going to let you back in. Okay. So this company got its license in Maryland, and Josh got a little irritated, so he sued him in federal court, which, you know, I wouldn't recommend you do, because one of the affirmative defenses is that weed's illegal under federal law. Why are you coming here? And for reasons I don't understand, Mackey and the attorneys represented him didn't raise the defense of illegality. Okay? So they got their ass spanked for $6.4 million in this breach of contract case. They also didn't appeal it. So in civil law, well, actually in all cases, if you don't raise affirmative defenses in trial, you don't appeal the case, you basically can kiss your ass goodbye, because you've waived all your opportunity to challenge that verdict. But what happened is that Josh decided he was going to go to Colorado, and I don't know all the reasons why, but he took the judgment from Maryland to Colorado, registered it there, and then sought an enforcement order. He wanted his money, goddammit. You guys ripped me off. I got a judgment to get you, want my money. Well, that's when Mackey and his attorneys first decided, and this was in a federal court too. That's when they first decided, well, we're going to raise this issue of it. The entire judgment was illegal. And the district court judge said, yeah, too late, too bad, so sad. Sit down and shut the fuck up. This judgment's going to stand. And then he fashioned an enforcement order where he told these Mackey and his company Trellis, which they call his alter ego, we want you to make your best efforts to sell your interest in Culta, which is the Maryland company that owned the license. Okay? And we want you to give all that money towards satisfaction of the judgment. We don't want you to do anything that's going to screw up the value of this asset. So everyone appealed. And they ended up in the appellate court, the 10th district, which covers Colorado. And it's a 3-judge panel, and the 3-judge panel split. And it got my attention because 2 of the judges decided that the illegality defense just ain't working here. You didn't raise it, you didn't appeal, so you got a judgment against you. Shut up, sit down. But the dissenting justice, he screamed and yelled, as I would expect federal judges to do, that this is all illegal. You can't come here and try to enforce agreements for illegal businesses, blah, 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 blah. And so the majority panel said, all right, we're going to send this enforcement order back down to the district court to see if you can fashion an order that doesn't cause anyone to abet a illegal cannabis business. In other words, we don't want you to be forced to have to go out and grow weed and process it and sell it to make this money. I don't know how that's going to happen. So I guess I'll wait to see what the district court has to say about the enforcement order. But it surprised me that a federal appellate court took the position that illegality is not a defense, that they're going to let this stand. The dissenting justice screamed that now illegality can be raised at any point in these proceedings, and it can vitiate the judgment. And the 2 other justices said, no, get out of here. So I don't know if this is hope that the federal courts are looking at the de facto realities on the ground, not allowing the nonsense to take away 8 legal businesses who are getting screwed, typically in business disputes, liars, breach of contract, things like that, and allowing this to proceed through the federal courts. Now, this can still be appealed to the U.S. Supreme Courts, I don't know, or to a full panel of the 10th Circuit where it's an in-bank. Everybody has to come in and do this. I don't know. We'll see how this works out. But I guess I'm a little more hopeful that the federal courts are loosening up their, we don't want to hear it, get out of Dodge type of stances that I've heard for decades from them. So I'm hopeful this means something positive for our industry, but you'll have to wait and see. I'm going to throw this back at you for what you people think, and let's see if we can talk about the future of cannabis in the federal courts.
Dale, what states and territories is the 10th Circuit cover?
It covers the eastern slope, if I'm remembering right, the eastern slope of the Rockies.
Yeah.
9th Circuit goes.
I thought it was Colorado area and all of that.
It should be the Front Range, because if I recall correctly, this gentleman's name is Josh Barch, right? Yeah, his dispensary in Denver was Doctor's Orders. I don't know if it's still there, but it used to be off of West 38th and around like Tejon or Quay Street right there. I lived right up the street. So it's got to be the Front Range that he's trying to get this judgment in. But I think this is a good sign that they're not just going to let people screw other people over and then put their head in the sand and say, well, you're all doing something illegal. They're actually going to try and allow these business issues to be litigated in front of a court.
Which actually is awesome in that court specifically, because my good friend Kata Wada brought a very well-organized lawsuit against her farmer business partner who had essentially gone in one night, closed everything down, took all the product, took all the money, took all the everything out of the place, left her with an empty place, and just destroyed it. And they threw it out, citing that this is cannabis, it's federally illegal, we're not getting involved. So I think that shows growth in this particular district specifically.
Would these decisions be setting precedent, or are they just only applying to these cases, Dale?
Well, they are citable, and it depends on where the case is brought. If it's not from your district, you can still cite it, but it's a little diminished authority. And a lot of these are district court decisions. And the district court in Maryland, because they didn't raise illegality, we don't have any idea how they would have ruled on the illegality defense. It just, and for me, I don't want to disparage anybody's character, but I'd be bitch slapping the associate in my office who failed to raise this and didn't appeal.
Right.
We'd be having some real problems. It kind of smells to me like there's some malpractice going on here, but maybe it was a strategic decision. I don't know. I just think that where we are right now, we've got a judgment that was confirmed, and it's registered in the Colorado district, and somehow this guy's going to try to get his money.
Quick question for you, Dale. When you slap this associate, do you use the palm, the backhand, or do you just actually use the actual lawsuit?
I hope it's the back.
No, I was in prison. You use the palm of your hand so you don't leave any marks on yourself.
Fair enough. Fair.
They say to strip you, Stevie George, you got no marks on you. And what happened to him? He fell down and bumped his head.
Yep.